Thank you everybody for joining us during your lunch hour. I hope that this will be not only an informative presentation, but somewhat entertaining so that the hour goes by quickly for you. We're here today to talk about mitigating social media risks before hashtags employees go viral. So 3 weeks ago, for those of you who follow the U.S. Supreme Court, I know we have almost an entire audience of attorneys, the Mahanoy Area School District versus BL case was heard. And for those of you who don't know, it was about a Pennsylvania cheerleader who had posted some pretty profane pictures and comments on her Snapchat. And really that case dealt with whether a school could discipline the employee for speech outside of the school. But about 3 weeks before that, Supreme Court Justice Clarence Thomas authored a concurring opinion in the Biden versus Knight First Amendment Institute at Columbia University case. And in that concurring opinion, he stated, today's digital platform provides avenues for historically unprecedented amounts of speech. And it is so true. I mean, for those of you who follow the media and not just social media, you know that over the past 12 months, there's been a ton of social media related to social injustice issues in our United States, related to COVID issues, the recent presidential election. And what we're seeing also, and we've been seeing it for many years, but I think with COVID and people being at home and out of the workplace, we're seeing it even more, is that social media is popping up a lot in the employment law setting. And so these are just some recent headlines. A PR executive fired over a racist tweet. A woman is fired for calling police on a Black man in Central Park, and the video of her doing that went viral. We see it also in lawsuits. Facebook post and firing of an Oklahoma worker leads to wrongful discharge claim, or a nurse's wrongful termination based on her Facebook post. And we have even more lawsuits. So it seems not just at the Supreme Court level, where I think that's kind of a sign of the time that social media is an issue in the cases that our Supreme Court's reviewing. We see it right down here in the workplace on a day-to-day basis. And so what we're going to cover here today is, first, I want to kind of give y'all an update on the landscape of social media, primarily in the US. We're going to talk to you about, very briefly, about benefits and risk of social media in the workplace. And then we're going to focus on the many, many laws that come into play when y'all as corporate counsel are trying to deal with social media issues in the workplace. And we're going to follow up with some other tips that we've learned just in dealing with client issues and through some of the cases that are out there. So let me have Maritza start with our social media today.
So as social media becomes more and more of the default of how people interact with each other and communicate, research studies begin to focus on who's using social media, what social media platforms are being used, and why. So when we look at who is using social media, the Pew Research Center began to track social media usage back in 2005. So in 2005, approximately 5% of US adults said they were using at least one social media site. By 2011, that number had already increased to 50% of US adults. Now in 2021, that number has increased to 72% of US adults who say they have at least one social media site. So that means that 7 in 10 Americans are using social media today. And as that number of users increases, it becomes more and more representative of the population as a whole. So this chart, second chart that we have here with multiple line graphs through it, is the number of US adults who say they have at least one social media website by education level. And as you can see, this reflects some college and college graduates having the most access to social media, followed by high school or less. And so what does this mean to you? It means that although our natural reaction when we see some folks getting in trouble because of the things that they do or say on social media, and we think that, you know, it's a dumb or stupid thing that they did. And as a matter of fact, people of all education levels are engaging with social media, which includes your very educated employers that are working for you today. And also the main social media platforms being used in America are YouTube and Facebook, and those are followed by all these other social media sites such as Twitter, Pinterest. As far as total numbers worldwide, Facebook seems to be the most popular with 3.79 billion, followed by all these others, and then Twitter with 350 million. And based on the trends that we're seeing, there's no doubt that these numbers of users will continue to increase. As far as how often Americans are using social media sites, this particular chart shows us that 70% of Facebook users say that they're accessing the website at least once a day. And then that's followed by 60% of Snapchat and Instagram users also saying that they access those sites at least once a day. Another study that's not mentioned on this page is looked at why employees access social media while on the clock, while at work. And the top 4 reasons that they found why employees access social media is for mental health breaks, to contact family or friends while they're at work, to do some kind of professional development or networking, and also to help solve some work-related problem. So now that we know that social media is definitely here to stay, Claudine's going to discuss some of the benefits and risks associated with social media.
Those numbers are extraordinary, and it was interesting in getting ready for the presentation today and looking back at a presentation from about 6 years ago. The figures were that about 3 in 10 adults in the United States were using, or folks in the United States were using social media, and now our numbers are, like Maritza said, 7 in 10. So there are a lot of benefits and a lot of risk to using social media. And when in one of the cases that we're going to talk to you about today is an American Airline case, but in the introductory paragraph of the opinion in that case, Judge Wolson, who's a U.S. District Court judge out of Pennsylvania, he said, as social media has become ubiquitous, people must grapple with its pros and cons. And he talks about the benefits. It's an efficient, unfiltered way to reach a mass audience. It's an easy way to stay in touch with long lost friends and professional contacts. It's a way to disseminate news and opinion in a broad audience. But then he goes on and summarizes kind of some of the cons. But posts often lack nuance. They don't allow for body language, facial expression, or tone of voice. And most posts are short and tend to be spur of the moment without the benefit of editing. And I think that's often what we see. But in the workplace, there are a lot of benefits. It does allow, like Maritza said, employees an opportunity to take a mental break. It can also strengthen relationships among employees. It can help you in recruiting. It can help you in your branding and your marketing. It also is a way to engage employees. It's a way to communicate with employees. Sometimes, even within our firm, with our main office out of New Orleans, it's a way for us to communicate in the event of disasters or hurricanes. And it's also used as a professional networking. So it has a lot of great benefits. But social media has a ton of risk too. It's a distraction from work. It takes away from productivity. It takes away from attention, maybe attention to safety and those sorts of things. It can result in brand vulnerability, damage to a company's reputation. If social media is being communicated between employees or with others, it can cause bullying and harassment. It can result in racist comments, sexist comments, ageist comments, all of those types of actions and words that kind of make your HR folks cringe. And it can also result in the disclosure of confidential information. Other risks are, it could be a security risk if your employees are accessing social media through the workplace and getting onto social media platforms that maybe have viruses and those sorts of things attached. And it can certainly cause negative exposure to the company. So what do we do? What do we do about all this? I mean, if we really have all of these folks, and we do, out there using social media, how do we identify the risk and how do we address the risk? And we thought the best way to handle that here today for you was kind of go over what we think are the big laws that impact decisions that you and your team at your company are going to make in terms of how you handle these risks. And so I'm going to turn it over. Well, let me first just briefly identify what those laws are. We're going to talk about anti-discrimination laws. We're going to talk about some laws and local laws that you may see if you're a multi-state employer. We're going to talk about the NLRA, the National Labor Relations Act, the FCRA, and the FTC. Well, what about the First Amendment? I mean, that's the law that you often hear people citing. I have a right to speech. I can post what I want. Well, let me just, this presentation is primarily for private employers. Non-governmental employers. And so in those work settings, the First Amendment doesn't apply. It only prevents the federal government from interfering with freedom of speech. But laws that we do have to be considerate of, and laws that I think frequently get social media decisions of companies into the courtroom, are anti-discrimination statutes. So we're talking about Title VII. And for those of you who don't do a ton of employment law, that's the law that protects people in terms of their protected class, like their gender or their sexual orientation or their race or their national origin or religion. We also have the Federal Age Discrimination in Employment Act. We have the Americans with Disabilities Act. We have Section 1981 that deals with race discrimination. And then here in Texas and states throughout the United States, we have correlating state laws, and even in some cities, we have local laws that are anti-discrimination in nature. And so when we're making decisions about social media risk, we need to keep these laws in mind. So our first tip in keeping these laws in mind is to have a policy and apply it uniformly. And there are two relatively recent cases that come out that I think are a great example of why this is important. I'm going to turn it over to Maritza to talk about the first one.
So the first case that I'm going to discuss is the Colleen Kozlowski case versus American Airlines. So Kozlowski filed a lawsuit after she was terminated for some Facebook posts that she made. Her lawsuit brought claims against American Airlines for gender discrimination under Title VII and the Pennsylvania counterpart, as well as disability discrimination and retaliation under the ADA. Shortly after the lawsuit was filed, American Airlines filed a motion for summary judgment. And so plaintiff Kozlowski was a female customer service agent. She'd worked for American Airlines for over 30 years. And as such, she was amongst the most senior customer service agents that American Airlines had. The comparator that she used during her discrimination case, we know was a male customer service supervisor. The plaintiff had a public Facebook page in which she included almost 100 of her coworkers as friends. And she posted two controversial messages to her Facebook account, which is what you could see on this slide now. Both of those comments related to race, which is a protective class. So I'll let you read those on your own. And Kozlowski also, in addition to these comments that she posted, she also posted an image of a t-shirt which had derogatory and offensive words and racist comments. After Kozlowski made these posts, American Airlines received many complaints from the employees that were her coworkers that she was friends with on Facebook, and they even received complaints from American Airlines customers in general. On the other hand, her comparator's Facebook post were these two: get rid of ignorant rednecks, and Trump supporters equal Nazi sympathizers equal stay away from me. Of these, American Airlines received no complaints. So the court found that, in fact, Kozlowski and her comparator were not similarly situated. Although his posts were inflammatory and had potentially offensive language, they were political in nature, where hers were objectively racist. The court found that Kozlowski could not present any evidence, or did not present any evidence, that anybody complained of the comparator's post. And so American could not have treated the two differently because they didn't even know about his post. Importantly, the court noted that American does not have to monitor all of its employees' social media feeds, but that if information about employees' social media feeds is brought to American's attention, it had to make sure to respond similarly to that information. The court found that Kozlowski's post created a controversy, and therefore American Airlines made a legitimate, non-discriminatory decision to terminate her based on her social media post. And American Airlines' motion for summary judgment was granted.
Tip number one, of course, was to have a uniform policy and apply it consistently. And the Chris Redford versus KTBS case is a great case about the importance of applying it consistently. In this case, we had Redford, who was an on-air crime reporter, and he worked for KTBS radio station. And KTBS had a social media policy that basically said, hey, if a viewer makes a negative comment to you on Facebook, we being somebody in management is to respond to that post. And so Redford had a Facebook page. It was a private Facebook page. And a viewer made a comment about one of the commentations, his commentary on a radio show. And in response, he commented back, some moron had to go and comment under this story, yada, yada, yada. I get so damn tired of stupid people. What the heck purpose does this serve? Sorry, but that crap just gets on my last nerve. At the same time, there was a Black female employee who also had not followed the social media policy and had responded to viewer comments. And so on the day that KTBS made the decision to fire Redford, they also fired Rhonda Lee. And Redford brought a discrimination suit contending that he was discriminated against based on his race. He was white, and his gender, he was male, and stated that his comparator was this female, Rhonda Lee, and that he had been treated differently from her. And he was treated differently because of his race and his gender. And the reason why he was contending he was treated differently is because she had made 3 posts and had just received warnings, and then she ultimately was fired, whereas he had just made this single post and then was fired. And what the court found when the defendant, KTBS, moved for summary judgment is that there was evidence to create a genuine issue of material fact as to whether Redford's behavior was comparable seriousness, and as such, whether the circumstances were nearly identical. In that case, KTBS argued, hey, you cannot compare Rhonda Lee's actions with Redford's actions because her posts weren't as serious, those sorts of things. But what the court said is that, look, the same exact language doesn't have to be used in order for these two folks their behaviors to be considered nearly identical. And therefore, she is a comparable, she is a similarly situated employee with comparable behavior, and he had created a fact issue. So the importance of both of these cases are to have a policy that clearly defines what's appropriate or inappropriate and apply that policy consistently. In other words, if you're going to ignore some social media posts, then be careful in acting on others unless you clearly can make a distinction, like in the American Airlines case, that in that case, the post incited um, a, a lot of controversy, whereas the comparable person's post in that case did not. So our tip number 2 is don't ignore online harassment and discrimination among employees, vendors, customers, clients, and independent contractors. And I'm going to have Maritza talk about the Christina Hayes case. But before I do, I want to let you know that it's not just online harassment with employees. Remember that the courts are clear that if the harassment is resulting from that of a vendor on an employee or a customer or a client, that also can be a potential harassment or discrimination claim. So Maritza, why don't you fill us in on this Christina Hayes case?
Sure. All right. So here, Ms. Hayes filed suit against Express Scripts, her employer, after she was terminated for a Facebook conversation that she was involved in while she was on leave. She asserted claims of racial discrimination under Title VII, as well as disability discrimination and retaliation under the ADA. Shortly after the suit was filed, her employer filed a motion for summary judgment. Ms. Hayes was an African American woman. She did work for Express Scripts for approximately 4 years as an insurance representative specialist. And while she was on leave, she participated in a conversation on Facebook with 2 other coworkers. And in part, the conversation went as follows. These comments are in relation to an African American male supervisor that these 3 employees shared in common. And as you can see, these posts were offensive and racist towards that supervisor, and also included a slew of curse words and emojis that were ultimately deemed to be offensive as well. And here, the court found that that Hayes was indeed fired for violating her employer's social media policy when she made vulgar, obscene, and racist comments about her supervisor on Facebook. In fact, she was actually fired the day she came back from leave, which formed the basis of her ADA claims. All employees involved in that conversation were fired because of that conversation. Ms. Hayes admitted to being involved in that conversation, but she denied that it violated her employer's social media policy, but failed to provide any kind of information of why it did not violate the policy that her employer had in place. The court found that Ms. Hayes failed to make a prima facie case of discrimination, and she could not rebut Scripps' legitimate non-discriminatory reason for terminating her. The court found that even if she could, she still had to establish that the reason for terminating her was pretextual, and plaintiff offered nothing tending to give rise to an inference of unlawful discrimination. And so ultimately, Express Scripts' motion for summary judgment was granted. And in this case, it's important to note that although the behavior occurred while Ms. Hayes was on leave, it's still enough to create a hostile work environment when she comes back. Had Express Script ignored her comments, we can see how Express Scripts could have opened themselves up to a lawsuit being filed by that African American supervisor had he been aware of these comments that were made of him based on his race.
So tip number 3 that we have in making sure you don't run afoul of anti-discrimination policies is to establish search protocols. If you have employees, whether they're in management, in recruiting, in hiring, in promotion decisions, those sorts of things that are online and looking at employees or prospective employees' social media posts, they are potentially learning information about that employee that may identify them with a certain protected class. For example, if on a social media post, an employee is sitting in a wheelchair, or a applicant or a prospective employee is, it is probably safe to assume that they have a disability and may fall into that protected class. And so tip number 3 deals with establishing search protocols. In other words, search, and these are search only publicly available information, verify the facts. Andrea and I worked on a case in which a company relied upon some information that was on social media that wasn't current. So you need to verify the facts, share your findings only on an as needed basis, and provide training. There was a case out of Kentucky. It was Gaskell versus the University of Kentucky. And in that case, the university decided not to hire Gaskell, a scientist, for a job. And after that decision was made, Gaskell sued the company because Gaskell had learned that one of the coworkers or employees of the university had circulated an email commenting about Gaskell's religion, which was visible on Gaskell's personal website. And so I think the takeaway here is that the mere fact that you have access to this information and that you access the information may potentially lead to a discrimination lawsuit if a plaintiff is able to present evidence that perhaps that information was relied upon in making the decision. Let me turn it over to Andrea to talk about another law that has a lot of impact.
Thanks, Claudine. As you just heard, the majority of the cases that we're seeing filed today as it relates to an employee's social media use are discrimination cases based on EEO laws. But there are a number of other laws that we don't want you to forget about when considering how to respond to an employee's probably improper use of social media. And the first of those laws is the National Labor Relations Act, the NLRA. And so, as you know, Section 8A1 of the NLRA prohibits employers from terminating or disciplining employees based on their engagement in what's called protected concerted activity. And generally speaking, protected concerted activity means employees have the right to act with coworkers to address issues in the workplace. This includes talking with each other, emailing, circulating petitions, participating in concerted refusal to work in unsafe areas or conditions. And the reason I'm bringing it up today is because not only does it apply to statements made in the workplace, but it also applies to statements made outside of the workplace, including those on social media. In fact, one NLRB decision even held that an employee liking a coworker's Facebook post was protected activity. I also think that this law is especially relevant now because a lot of employers are reopening their physical offices and returning employees to the workplace. So just be mindful that discussions about posts about an employer's response to COVID or their return to work precautions may very well be considered protected concerted activity since it relates to the health and safety issues in the workplace. And so our tip number 4 is this. Number 1, consider the NLRB's guidance, and number 2, be specific. So I know all of y'all know this because you have probably heard a million presentations since the decision of the Boeing decision in 2017. And as you know, whenever the NLRB, the National Labor Relations Board, considers a policy, they balance a couple things. And that's 1, the nature and extent of the potential impact on the NLRA rights. And they balance that with the employer's legitimate justification for the policy or the rule. And when they consider those two things, they take it from the perspective of a reasonable employee and whether that person would feel that their NLRA rights were being infringed upon. Since Boeing, though, the NLRB has been giving employers more latitude to discipline employees for social media conduct that violates employer rules or even threatens the employer's reputation. For example, just January of this year, the NLRB reversed the decision of an administrative law judge, finding that a social media policy that prohibited, quote, inappropriate communications online, whether at work or at home. And that's just in line with a number of cases that have come out of the NLRB recently. In August of 2020, the NLRB found lawful an employer social media policy that required employees to, quote, be respectful and professional when using social media tools, so as to effectively safeguard the reputation and interests of the employer. But that being said, it's not without limits. And so in July 2020, the NLRB analyzed a policy and it held that it was unlawful, and it stated it held unlawful a non-disparagement clause that prohibited statements that were, quote, intended to injure the reputation of the company or its management personnel with customers and employees. And at first glance, I didn't realize what's the difference between that and the other cases that I just read. But if you here at the end of that statement, it said that they are prohibiting statements that were intended to injure the reputation of the company or its management with customers or employees. And so focusing on the rules prohibition against statements to other employees, the NLRB determined that it was unlawful, as there's no justification that would outweigh an employee's right to discuss their working conditions. But keeping up to date on these decisions and the new guidance that's coming out from the NLRB is going to be important because the composition of the NLRB is likely going to change in August of this year. One of the board members' term expires in August, and President Biden will have an opportunity to appoint a new member. So while we've had a slew of very employer-friendly cases, we expect that a number of those employer policies that were found lawful today, or since going, may be considered unlawful in the future. So it's really important just to stay up to date on that and try to monitor some of the recent decisions coming from the NLRB, especially post August 2017. And then you'll see on the bottom of tip number 4 is include a disclaimer. And so as a final precaution, we always recommend that our clients include a disclaimer in their social media policy. We say something generally like this, and this is the message we want to communicate, is that nothing in the policy is designed to interfere with their rights to discuss the terms and conditions of their employment. And so that's always a good fail-safe. That way, whenever the NLRB looks at everything, they can take it into context and know that that's not the intent of the employer. So in this tip number 4, I only talked about advice as it relates to the NLRA. Later on in the presentation, Claudine's going to visit and address some additional tips on how to for your social media policy. The next law that I wanted to discuss with you today, though, is the Fair Credit Reporting Act. And I think this is a law that probably would often go unnoticed in this area, but when social media-based screening is conducted by a third party, the FCRA applies according to the EEOC and the Federal Trade Commission. So our tip number 5 is this: ensure your compliance when using consumer reports. And this would generally include all the requirements of the FCRA. And so you've got to make sure that you're getting their employee or applicant's consent in writing. Are you providing the proper notices? Are you giving the employee or the applicant an opportunity to dispute the information obtained? Are you taking reasonable steps to ensure that the information that you obtained is accurate and relevant? Are you certifying that the information won't be used in a manner that violates EEO law? And are you keeping the data secure and disposing of it properly whenever it's no longer needed? We bring this up also, and I know it's a very specific law, but we bring it up to your attention because employers could be fined per violation under the FCRA. And so these types of violations often lend themselves to class action lawsuits. And so that's the real problem here is if you're likely doing this for one employee, you're probably doing it for all of them while violating the FCRA, and then that could lead to a class action lawsuit against you. Tip number 6 is for our multi-state employers, because I just want to bring your attention to this. There are a lot of state laws and local ordinances that protect certain employee activities on social media. And in preparing for this presentation, I must admit that I was just as shocked to see as many as you probably are right now. you can see on this chart on this slide right here that some states prohibit an employer from retaliating against an employee just generally for lawful off-duty conduct. And so I know that may raise a few eyebrows, but one thing to keep in mind is even in these states, though, online speech that constitutes workplace harassment or discrimination, that's not going to be protected under that first column of laws because it has to be lawful conduct. And then, as you can see with the remaining columns, other jurisdictions protect employees from engaging in political activities, expressing political opinions, or engaging in election-related speech. And I know this does sound somewhat concerning because how do you draw that line? But it is important to keep in mind that expressions of racism or other harassment, like you saw in the first case that Maritza discussed with you, that's not political speech, and that wouldn't be considered political speech under these statutes. So those are some of the more specific nuanced laws that I wanted to share with you. I'm going to now turn it over to Claudine, and she's going to discuss some additional tips with you.
You know, in our presentation today, we are addressing just laws in the US, primarily federal laws and Texas laws. But keep in mind that if you have employees over in the EU or you have employees in other foreign jurisdictions, that there are unique laws that apply to monitoring of social media use at work, those sorts of things. And so you would want to look into those before making decisions about employees in those jurisdictions. So in terms of some more tips, I want to go back to social media policies. You know, Andrea visited with you about some guidance that we get from the NLRB, but the other tips that we want to give you just from our experience in assisting clients are, one, obviously, is to be proactive and not reactive. It's a lot easier to address a post before hashtags employees go viral if you actually have a social media policy in place and you've put careful thought into it and you're able to follow it. But also the other thing you want to include in your social media policy is a clear purpose. There was a case out of Delaware, and in this case, activities director for a nursing home, Jones versus Gulf Coast Healthcare of Delaware, he had gone out on FMLA leave, and on his Facebook, he had posted pictures of himself on at Busch Gardens and down in St. Martin. And so the company fired him, and they fired him for violations of the social media policy. But in the lawsuit, the defendant first obtained a motion for summary judgment, and then that decision was appealed. And on appeal, Jones presented evidence to the court, and the court found that there was evidence that the purpose of the nursing home facilities policy was to prevent employees from posting harmful or negative comments about the company's staff or facilities. And obviously, his post about being at Busch Gardens or St. Martin, while that may have been terminable under a different theory, really wasn't a violation of the social media policy when you looked at the purpose. And so that's why I think it's important. You know, a lot of times we use generic or we use just form policies that we find online, is for you to carefully think about, okay, what is the purpose of my company's policy for social media? Is it to protect confidential information? Is it to respect our EEO guidelines and rules? And I go ahead and identify those in your policies so that you can rely on those purposes in making employment decisions. The other thing you want to do with your policies is you don't want them to be overly aggressive. You want to balance the actual legitimate business interest of your company with the employee's rights and the whole idea or the known fact that employees are going to be on social media, and they're probably going to be on social media in the workplace. And so you kind of want to keep that in mind in how you're drafting your policies. You also want to be specific about the content that's in scope. I mean, what is it exactly that you are concerned about with social media posts, and identify that specifically so that you can rely on those policies. So other things to consider is you want to define social media. And I mean, the number of platforms are ever increasing. So just listing out, a few platforms may be okay, but it would be better probably to have a more generic definition of what social media is. And then you want to define the appropriate purpose. So I want to return to that Chris Redford versus KTBS case. Remember, that was the case with Redford, who was the on-air crime reporter who responded to the viewer with a post that contained curse words, and he had the fellow employee, Rhonda Lee. Well, in that case, in addition to the defendant arguing that the plaintiff couldn't establish his prima facie case because there wasn't a comparable person that was treated differently, and that's the point I addressed earlier, the defendant also argued, hey, we had a legitimate business reason for terminating this employee. He violated the policy. And recall, I told you that the policy said that if an employee was responding to a negative post by a viewer on Facebook, that they should allow this certain person in management to respond to the viewer. And obviously Redford hadn't done that. He had responded with his response that contained the curse words. Well, during the summary judgment phase, Redford presented evidence that the policy really was only applied to KTBS's Facebook page, and that he actually made the comment on the private page. So again, that's the importance. And as a result of that evidence, what the court found is that, yeah, there was a genuine issue of material fact as to whether KTBS's non-discriminatory reason for firing Redford was pretextual. In other words, did he really violate the policy? Because if the policy only applied to the company's Facebook page, then him responding on his private page was not a violation. And so that again goes back to our point that you need to make sure that your policy is specific and that you're following that policy. Another thing to include in your policies is talk about whether or not employees are allowed to reference the company name, the company logo, or trademarks. Talk about use during work. I mean, if you have a work environment that for safety reasons, absolutely you don't want your employees to be on social media, then perhaps have a portion of the policy that identifies those workers that policy applies to. Talk about who in management will be responsible if there's concerns about the policy, who will look into it, who will monitor, who will review an employee's social media if there's a question that perhaps they've done something to violate the social media policy. Also, I think it's important to address disciplinary measures for violation, and you need to follow those measures. We learned that also in the Redford case consistently. And finally, I think it's a good idea, and there's a few reasons for this, to reference other policies. One is oftentimes, and lawyers are guilty of this, we draft these really, really long policies because we want to cover every issue that might come up. Well, you need to have a policy that I'll just say is user-friendly. You need to have a policy that your employees are able to read and understand. But there are a lot of other policies that your company may have that should be addressed in your social media policy. And so I personally believe the best way to handle those, rather than restating your EEO policies or your internet and equipment use policy, is to simply reference those policies. And here on this page are some of the policies that I think are important to reference because they would come up in an employee's use of social media. And those are like your EEOC policy, your workplace violence policy, your internet and equipment use policy, your confidential information policy, your conflicts of interest policy, your company use policy. And what I mean by that is have a separate, if you as a company are engaged in social media, if you do branding through social media or marketing through social media, I think it's a good idea to have a separate policy for that, that's separate and apart from an employee's use of social media outside of their specific duties and responsibilities for the company and social media. And I want to make one point about this, and this could be a presentation in and of itself, but if your company is using a social media or having employees use social media to promote your brand or your services or your product, it's important for you to keep in mind the Federal Trade Commission Act. Section 5 of that talks about how if you are a person who has a material connection to the company, the product and service, and you're out there promoting or you're engaging in a manner that would lead a consumer to believing that you're promoting it, then you need to have truthfulness, you need to have transparency, and you need to have those sorts of disclosures. And so it's important, if you do have employees out there that you're asking to engage in social media, that they are following the endorsement guides of the FTC. And those, by the way, were recently updated. And in my opinion, the FTC website is a pretty user-friendly one, and it can give you a lot of information on how to deal with that. I want to make this other quick comment about employees engaging in social media because you've asked them to. And that is, just be aware of wage and hour issues. If they are non-exempt employees, in other words, they're not exempt from overtime, they're your hourly employees or a salaried employee that's not exempt, and they're outside of work, like on the weekends, going to parties or whatever, and promoting your product or your services, it's important to consider whether or not that time would be deemed compensable, and therefore wage and hour issues might apply. So other considerations, of course, we as employment lawyers always love to talk about training. Provide training to your employees on your social media policy. Provide training to the folks in your company that are engaged in recruitment or hiring on if you have certain protocols in place for accessing social media. Train them on how to handle that, and we covered that in one of the tips. Also, carefully consider your termination and disciplinary action. In getting ready for this presentation, I listened to a podcast, and they had referenced there was an employee up in British Columbia, up in Canada, and he had received from an American employer a bottle of barbecue sauce as his Christmas gift. And so he made a somewhat, not very friendly post about work for this multi-million-dollar US company, and I get a bottle of barbecue sauce for Christmas. And so after Christmas, the employee was brought in and was terminated for the post. Well, it ended up backfiring on the company because that employee, who obviously was engaged somewhat in social media, decided to post why he was terminated, and his post went viral. And so, today we have talked about a lot of the legal considerations in how you handle these social media risks. But what I want you to keep in mind is there's a lot of PR and business decisions. And when you are going to respond to a social media post through another social media post, I think it's important that you have an expert within the company or outside of the company involved in that response. I also think it's important that it's timely. But again, this presentation today was primarily about the legal issues involved. The other thing, as an employment lawyer, I want to mention is document your termination decision and your disciplinary action decision. That was one of the issues in the Jones case, where the employee had posted that he was at Busch Gardens while he was supposed to be on FMLA, is that the employer, at least the way the evidence was presented in the appeal, was all over the place on why they actually terminated him. And they wanted to hang their hat on, well, he violated the social media policy, but they didn't have very good documentation in place. And so we always like to see documentation. The other thing is preserve relevant posts and do it quickly. Andrea and I worked on a case where employee had been injured on the job, and shortly after his injury, he posted that he was going to bring a gun to work on his wife's Facebook page. And so before we were involved in the case, the employer terminated the employee. Well, lo and behold, when it's time to defend the case, that post was no longer there. And we all know that a picture speaks 1,000 words. And so, or maybe the saying's 1,000,000 words. And we didn't have that picture. Yeah, we had the testimony of fellow employees saying, I saw the post, that sort of thing, but we didn't have the post and we didn't have the ability to authenticate it as admissible evidence in the courtroom. And then finally, what I just want to mention is litigation hold notices. A lot of us have Form 1s that we've used over the years. And I just want you to, take a quick look at those and make sure they're up to date, because a lot of those notices are drafted in a manner that maybe don't take into consideration how frequently management or other employees are using social media in the workplace. So I'm going to take a look at this chat. I should have said this at the beginning, and see if there are any questions here. And I don't see any, but if you have the ability to hold up a hand and have a question for us, we've got just a couple minutes left. Okay, well, I do want to thank all of you for your time today and your attention. I want to thank ACC for allowing Phelps to sponsor this event. We really appreciate it, and we hope that you got a lot out of the presentation today.